Welcome, and thank you for joining us. Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, if you find this content valuable, we kindly request you to like the video, subscribe to the channel, and activate the notification bell to receive updates on future episodes. Let's begin.
Welcome, curious minds, to another deep dive. Today, we're peeling back the layers on a really big legal battle, one that fundamentally reshaped how innovation gets protected, especially in, the super fast-paced world of biotech. We're talking about a case, Ariad v. Eli Lilly, that went all the way to the highest patent court in the U.S. It sparked some pretty intense debate among judges, legal scholars, the scientific community, everyone, really. It's kind of a classic, what did you really invent story, but with huge implications for everything from, groundbreaking university research to the medicines you might actually take.
That's exactly right. And this isn't just about, one patent. It digs deep into the very foundation of what people call the patent bargain, that sort of trade-off. Inventors disclose their discoveries, and in exchange, they get exclusive rights for a time.
The quid pro quo.
Precisely. And the court here was really grappling with what that disclosure part truly means, what you actually have to show.
So let's unpack this for you. We'll explore the science behind it, the legal arguments that clashed head-to-head, and crucially, why this decision still sends ripples through the world of invention and IP today. Get ready for, hopefully some surprising facts and a deep dive into Ariad Pharmaceuticals versus Eli Lilly and Company. Okay, first things first. Let's get everyone oriented with the essential details, the who, what, when, where of this judgment, kind of the basic framework for our dive.
Sounds good. So this specific judgment comes from the United States Court of Appeals for the Federal Circuit. That's basically the top court for patent appeals in the U.S.
Right.
The official case number, if you're looking it up, is 2008-1248. And the judgment itself was decided on March 22, 2010.
And this wasn't just a standard panel of 3 judges deciding this, was it? This felt like a bigger deal.
Oh, much bigger. This is an en-banc decision. That means the full court, almost the full court, heard the case together. That happens when the issue is considered exceptionally important or when they want to resolve conflicting precedents. The main opinion, the majority opinion, was filed by Circuit Judge Lori. He was joined by a whole raft of other judges, Chief Judge Michel, Judges Newman, Mayer, Bryson, Gajorsa, Dyke, Prost, and more.
A full house.
Pretty much. And what's also really telling is that it generated significant separate opinions, concurrences, dissents. That just highlights how complex and, frankly, contentious the legal questions were.
Okay, so who were the main players slugging it out in court?
Right, so on one side, the plaintiffs, or technically the plaintiffs' appellees because they won below initially, you had a consortium of really prominent research institutions. Ariad Pharmaceuticals, Inc., MIT, the Whitehead Institute for Biomedical Research, and Harvard College. We'll just call them Ariad collectively for simplicity.
Makes sense. And defending against their patent claims.
That would be the defendant appellant, Eli Lilly and Company, just Lilly.
Okay.
And the legal firepower was significant. John Whelan argued for Ariad, Charles Lipsey for Lilly. But what's also fascinating is the outside interest.
Right.
The court got 25 amicus briefs.
Wow, 25.
Yeah, friend of the court briefs. From universities, industry groups, even the U.S. government filed one. And interestingly, the majority of those briefs, including the government's, actually supported the court's existing interpretation of patent law, the one Lilly was arguing for.
That really does underscore the stakes, doesn't it, if the government and so many others are weighing in?
Absolutely. It shows this wasn't just about Ariad and Lilly. It was about a fundamental principle of patent law that affected a lot of people.
Okay, so now we have the who, what, when. Let's dive into the story. The core facts, the timeline that led up to this big Federal Circuit decision. What exactly was Ariad's discovery that started it all?
Okay, let's try to break down the science a bit. The patent, the 516 patent, is all about something called NF-B. It stands for nuclear factor kappa B.
NF-kappa B.
Okay, think of it as like a master control switch inside your cells. Ariad's inventors were the first to identify this switch. It's technically a transcription factor, and figure out how it works to activate gene expression.
Okay, hold on. Transcription factor, gene expression. Quick translation for us.
Right, sorry. A transcription factor is basically a protein that helps turn specific genes on or off. It controls whether the information in a gene gets used.
Got it. Like a dimmer switch for genes?
Sort of, yeah,
Oh.
or an on-off switch. And gene expression is just that process, the gene's instructions being read and used to make something, usually a protein, that does a job in the cell.
Okay.
So Ariad found this NFLB switch is crucial for the body's immune response. When you get an infection, say from bacteria, molecules from those bacteria-like lipopolysaccharides trigger NFD.
Okay.
Normally, NFB hangs out inactive in the cell's main body, but when triggered, it gets released, travels into the nucleus, the cell's control center, and flips on the genes needed to fight the infection.
So a really fundamental discovery about how our immune system works that sounds huge. Where does the patent come into this?
Well, the inventors realized that while NFB is essential, having too much activity, triggering excessive production of things called cytokines.
Those are signaling molecules.
Exactly, immune signaling molecules.
Yeah.
Too many cytokines can actually be harmful and contribute to diseases like sepsis or inflammatory conditions. So they thought, if we could artificially reduce NF-chi activity, maybe we could treat these diseases.
Ah, the therapeutic potential.
Right. So on April 21st, 1989, they filed a patent application. It described their discoveries about NF-k and claimed methods for reducing its activity in a cell to regulate those cellular responses.
1989. Okay, that date seems important. So fast forward, they eventually got a patent.
They did, quite a bit later, actually. U.S. patent 6,410,516 was issued on June 25, 2002.
Wow, 13 years later.
Patent prosecution can take a while. But here's the kicker. On the very same day the patent issued, Ariad sued Eli Lilly.
The same day. Talk about being ready.
They were ready. They alleged that two of Lilly's drugs, Evestat and Jigris, infringed certain claims of their brand new patent, specifically claims 80, 95, 144, and 145.
And what kind of claims were these? Were they very specific?
No, that's the key point. They were what are called genus claims. Very broad. They basically claimed any method that achieved the desired result, reducing NF-key activity by interfering with its binding.
Any method.
Pretty much. The patent document hypothesized three general classes of molecules that might work: specific inhibitors, dominantly interfering molecules, and decoy molecules. But the claim was for the result, essentially.
Okay, so they sue Lilly. What happened in that first round at the district court?
Well, after a pretty long trial, 14 days in April 2006, the jury actually sided with Ariad. They found Lilly had infringed those claims.
Wow.
And crucially, the jury also found the claims were not invalid. Lilly had argued they were invalid for several reasons: anticipation, lack of enablement, and lack of written description. But the jury rejected those arguments.
So a big win for Ariad initially. The district court judge agreed.
Yes, the judge denied Lilly's motions to overturn the jury's verdict. So Ariad won round one.
But clearly not the end of the story, since we're here talking about the appeal.
Exactly. Lilly appealed to the Federal Circuit. And in April 2009, a three-judge panel of that court issued a decision. They agreed with the lower court on one point: no inequitable conduct by Ariad.
Okay.
But critically, they reversed the jury's verdict on written description. They held Ariad's claims were invalid because they lacked adequate written description.
Ah, so the first appeal already flipped the script on validity.
It did. And that panel decision really brought this long, simmering debate about the written description requirement to a boil. It prompted Ariad to petition for a rehearing en banc by the full court.
Which the court granted.
Yes, citing the issue's importance.
Yeah.
They specifically asked the parties to brief whether Section 112 even has a written description requirement separate from enablement, and if so, what its scope and purpose is.
So the stage was set for a major clarification.
Absolutely. That led to the big en banc arguments in December 2009, and ultimately to this landmark decision we're unpacking today.
Okay, this is where it gets really into the legal weeds, but it's fascinating. The core question wasn't just infringement, but a really fundamental requirement for getting a patent in the first place: how you have to describe your invention.
Exactly. The whole fight boiled down to interpreting one specific part of the patent law. 35 U.S.C. Section 112, first paragraph.
Let's hear that language again.
Okay, it says the patent specification shall contain a written description of the invention and of the manner and process of making and using it in such full, clear, concise, and exact terms as to enable any person skilled in the art to make and use the same.
Right, it's dense, but you can sort of see two potential requirements in there: describing the invention itself and describing how to make and use it.
Precisely. And the huge legal fight was, are those two separate tests? Or does the second part, the enable any person skilled in the art, bit applied to both descriptions.
Okay, what was Ariad's take on that dense language?
Ariad argued for what they called a plain reading. They said, look, there's no separate written description requirement. It's all about enablement, meaning both describing the invention and describing how to make and use it are judged by that single standard. Are they described well enough to enable someone skilled in the field to make and use the invention?
Okay.
For Ariad, identifying the invention was just part of enabling it, and they argued that the original claims you file should basically count as their own description. They pointed to how patent law evolved historically, suggesting Congress had streamlined things to focus just on enablement.
So a simpler, maybe more practical view. If you tell people enough to build it, you've met the description requirement. Done. What did Lilly argue against that?
Lilly strongly disagreed. They said no. The statute clearly lays out 3 distinct requirements in that paragraph. First, a written description of the invention. Second, a description of how to make and use it, which is enablement. And third, the best mode requirement, which is about disclosing the best way you know to carry out the invention.
3 separate hurdles.
Yes. And for Lilly, that first one, the written description of the invention, is a standalone test. It applies to all claims, original or amended. And its purpose is different from enablement.
So?
Its purpose, Lilly argued, is to prove the inventor actually possessed the claimed invention when they filed the patent, that they had fully conceived of it, not just hypothesized it or provided a research goal. It's about showing you had it, not just that you enabled someone else to maybe figure it out later.
Possession. That sounds like a key concept.
It is. Lilly said 2 centuries of court cases supported this separate requirement, and Congress effectively adopted that interpretation by keeping the language similar over the years. And, crucially, they argued Ariad's patent failed this test.
Why?
Because the claims were way too broad, covering any way to reduce and thieve activity, but the patent specification itself didn't actually describe how to do that sufficiently back in 1989. Lilly called it little more than a research plan.
A research plan, not an invention already possessed. Okay, so 2 fundamentally different readings of the law. How did the full Federal Circuit, the en banc court, finally rule?
The Federal Circuit came down decisively on Lilly's side. They reaffirmed their long-standing view. Yes, Section 112, first paragraph, does contain a written description requirement that is separate and distinct from the enablement requirement.
Wow, okay, so they confirmed that the separate test exists?
Confirmed it emphatically. And applying that test, they reversed the district court and held that Ariad's asserted claims were invalid for lack of written description.
A huge win for Lilly then, and a major loss for Ariad. What was the court's core reasoning for sticking with this separate requirement?
It was layered. First, just looking at the statute's text, they agreed with Lilly's grammatical analysis. They argued that the enabling phrase in such full, clear, concise, and exact terms as to enable only modifies the second part of the manner and process of making and using it.
Not the first part. A written description of the invention.
Correct. They said the requirement for a written description of the invention stands alone. Reading it Ariad's way, they argued, would make some words in the statute meaningless, which goes against basic principles of how you interpret laws.
Okay, so grammar was part 1. What else?
Second, they leaned heavily on Supreme Court precedent and the principle of stare decisis, basically, adhering to past decisions for stability and predictability.
Right, following the history.
Exactly. They pointed to older Supreme Court cases like Schreiber, Schroth, and Festo, arguing these cases consistently recognized a separate written description requirement, even if implicitly sometimes. As a lower court, the Federal Circuit felt bound by that precedent. They couldn't just ignore it.
Even if some people thought those older cases were about slightly different issues.
Right. The majority felt the principle was there. And they stressed this separate requirement had been Federal Circuit law for decades, part of the settled expectations of inventors. Overturning it would cause too much disruption.
So, statutory text and precedent were key. How did they apply this to Ariad's actual patent claims, especially since these were original claims, not added later?
That's a critical point.
Yeah.
The court made it crystal clear. The written description requirement applies to all claims, including original claims. Just because a claim was present in the application as filed doesn't mean it automatically satisfies the requirement.
Okay.
The specification as a whole still has to objectively demonstrate that the inventor actually possessed the full scope of the claimed invention as of the filing date. It's about showing the inventor actually invented the invention claimed.
Possession again. So it's not enough to just state the claim broadly in the application. The description backing it up has to show you really had control over that whole scope back then.
Precisely. And this becomes a real hurdle for broad genus claims, especially those defined by function, describing what something does rather than what it is.
Like Ariad's claims for any molecule that reduces NF-key activity.
Exactly. The court cited earlier cases, including another famous one involving Eli Lilly, Regents of the University of California v. Eli Lilly, and Fires v. Revel. Those cases established that just stating the generic claim language isn't enough.
You need more.
You need to support the scope of that genus claim by describing a representative number of species within that genus, or identifying common structural features that allow one skilled in the art to recognize members of the genus. You need to show you possess more than just the general idea.
And Ariad's patent, according to the court, didn't do that.
Correct. The court found Ariad's claims were generic functional claims. While the patent talked about 3 potential classes of molecules, inhibitors, interfering molecules, decoys, the specification failed to adequately describe actual examples or identify characteristics for those classes as of the 1989 priority date.
The devil was in the 1989 details, or lack thereof. Can you walk us through how the court picked apart those 3 classes?
Sure. It's quite revealing. For specific inhibitors, the only real example hinted at was a protein called IB. But the patent didn't actually describe IB sufficiently in 1989. Key data, like its DNA sequence shown in a figure, wasn't added until 1991. Too late. The 1989 description was just a vague functional description and an invitation for further research. Not enough.
Okay, one down.
For dominantly interfering molecules, here the specification provided 0 examples. Worse, it said they'd only work if certain parts of the NF-key protein were spatially distinct, something the inventors didn't know in 1989. The court called this a wish, or arguably a plan, not a description of a possessed invention.
Just a hypothesis, really.
Pretty much. And again, later discoveries couldn't save the 1989 description for decoy molecules. Here, they did propose some structures, but the description of how to use them was vague. It just said NFD would bind the decoy and negative regulation can be affected. No real link between the structures and a working method in 1989. A paper discussing their use came out in 1990 again, too late.
So across all 3 categories, the description in 1989 just wasn't specific enough to show they actually had working examples covering the breadth of their claim.
Exactly. The court concluded the jury didn't have substantial evidence to support finding adequate written description. The support was just too thin for the vast scope claimed. And that's when they dropped that famous line. A patent is not a hunting license. It is not a reward for the search, but compensation for its successful conclusion.
Oof, a powerful statement. It really frames their view. You get the reward after you've successfully found something concrete and described it, not just for pointing in a promising direction.
Precisely.
Now, while that majority opinion was decisive, this wasn't a unanimous decision, right? There were judges who agreed with the outcome for slightly different reasons, and others who strongly disagreed. Let's hear about those voices.
Right, the concurrences and dissents are really illuminating here. Judge Newman, for instance, joined the majority but wrote separately to offer additional views.
What was her focus?
She highlighted what she saw as the core tension. Patenting basic scientific research versus patenting demonstrated practical application. She acknowledged Ariad's concern that this ruling might hurt universities trying to patent early discoveries.
A valid concern.
But for Judge Newman, the overriding policy goal of patent law requires that transition from theory to practice, from research plan to demonstrated utility. You need to show you've applied the basic science. She even cited the very old O'Reilly v. Morse case involving the telegraph to make the point that you can't patent a basic scientific principle itself, only its concrete application.
So even in agreement, she acknowledged the policy struggle involved. What about other concurring opinions?
Judge Gajarsa also concurred, but somewhat reluctantly, it seems. He called the actual text of Section 112 a model of legislative ambiguity that reasonable people could disagree on.
He admitted the statute wasn't clear.
Pretty much. He said he only joined the majority to provide some needed clarity in a confusing area of law. But he expressed serious doubts about whether a separate written description requirement was truly a necessity or had much practical impact, outside of specific situations like determining priority between inventors or policing new matter added later to an application.
Interesting. He wasn't convinced it did much heavy lifting on its own.
He pointed to studies suggesting it rarely invalidated patents independently of enablement issues. He felt enablement was often sufficient. Ultimately, he thought only Congress could really sort out this thicket, not the courts.
It sounds like he felt the court was Maybe overstepping, getting into legislative territory?
Which leads us to the dissenters, who were even more forceful, right?
Oh, yes. Judge Rader, joined by Judge Lynn, filed a strong dissent, well, technically dissenting in part and concurring in part, since they agreed on the minor inequitable conduct point. Rader flatly stated the separate written description requirement has no statutory support.
Wow, blunt, very. He argued the majority's reading of Section 112 was strained. He insisted the plain language meant the enablement standard applied to both parts of the description. He called the majority's vague possession notion problematic because it left the description requirement without a clear legal standard.
He felt possession was too fuzzy.
Essentially, yes. And he argued the majority misread the Supreme Court precedents, like Schreiber-Schroth. He believed those cases were really about policing new matter added to applications or sorting out priority dates, not about invalidating original claims for lacking description.
So he saw the majority as taking those old cases out of context.
He did. He specifically targeted the Regents v. Little case from 1997, calling the application of the doctrine to original claims, in that case, a fabrication and new law that created unintended and deleterious consequences.
Strong words. What kind of negative consequences did Rader foresee from this separate written description doctrine?
He worried it created conflict with other established patent law principles. For instance, claim construction, where claims are normally interpreted in light of the specification. He also felt it undermined the concept of blocking patents.
Explain blocking patents quickly.
That's where someone gets a broad pioneer patent on a new genus or concept, and later inventors get narrower patents on specific improvements or species within that genus. The pioneer patent blocks the improvers until it expires. Rader argued this new doctrine would weaken pioneer patents, suggesting mere improvements will likely invalidate genus patents, which could discourage truly groundbreaking broad inventions.
So a chilling effect on pioneering innovation.
That was his fear. And Judge Lynn, joining Rader, hammered these points home. He reiterated that the only reasonable reading of the statute ties enablement to both description clauses. He criticized the majority's poorly defined standard for possession and argued enablement alone was perfectly capable of handling overly broad or purely functional claims. Like Gujarsa, he pointed to studies showing the limited independent impact of the written description doctrine.
So a real clash of philosophies about statutory interpretation, precedent, and the policy goals of patent law.
Absolutely. The dissenters saw the majority as creating bad law with negative consequences, while the majority saw themselves as holding established precedent and ensuring patents reflect actual possessed inventions.
This has been a fantastic deep dive into the legal arguments. So stepping back, what's the lasting legal significance? Why does Ariad v. Lilly still matter so much today, especially for our listeners interested in innovation?
Well, its primary significance is that it cemented the separate written description requirement as a core part of U.S. patent law, definitively distinct from enablement. The full Federal Circuit spoke with force on this.
It's settled the debate, at least for now.
For now, yes. It clarified that merely enabling someone else to make and use an invention isn't sufficient. The patent application itself must demonstrate, through its description, that the inventor possessed the full scope of what they were claiming right back at the filing date.
Proving you truly invented it back then, not just the concept or the pathway to it.
Exactly. And this has huge implications, particularly in fields like biotechnology, pharmaceuticals, complex chemistry, even cutting-edge software, where inventions often start as broad functional concepts.
How so?
It means inventors in these fields generally can't just claim a desired result, like any drug that inhibits protein X, or a vast genus of possibilities without providing sufficient concrete support. They need to show they actually possessed representative examples or identified unifying structural features that justify that broad claim scope at the time of filing.
It really pushes inventors to have more data, more concrete examples earlier in the process if they want broad protection.
It does. It actively discourages patents that function as mere hunting licenses, claims on problems or research goals rather than achieve solutions. It reinforces the idea that patents reward the successful conclusion of the inventive journey, not just the start.
This must profoundly shape how researchers, maybe especially in universities or early-stage startups, approach patenting. You can't just file on the brilliant idea, you need to back it up robustly from day one.
Absolutely. Yeah. It forces a much more rigorous approach to drafting the initial patent application. The court sees this as upholding the quid pro quo. The public gets a meaningful, concrete disclosure of what was actually invented in exchange for granting exclusive rights. It's about balancing the incentive to invent with preventing inventors from overreaching and trying to preempt the future before it has arrived, as the court put it.
Preventing overreach, a key theme. Okay, as we wrap up this deep dive, if there's just one crucial idea, one takeaway message from Ariad v. Eli Lilly that our listeners should really internalize, what would it be?
I think the single most important takeaway is this. Under U.S. patent law, describing how to make and use your invention isn't enough. You also have to provide a written description that clearly shows you actually possess the full scope of what you are claiming right from your earliest filing date. This is especially critical for broad claims, functional claims, or claims in unpredictable fields like biotech. That written description hurdle is separate, it's real, and it demands concrete support.
Describe how, and you describe what you actually had. Got it.
That's the essence. It ensures the patent scope aligns with the inventor's actual contribution at the time.
And there you have it, a deep dive into Ariad v. Eli Lilly, a case that really grows into sharp relief that complex interplay between scientific discovery, the precise language of the law, and ultimately the public interest. It reminds us that how you describe your invention can be just as critical as the invention itself.
Indeed, it underscores that the quest for scientific progress doesn't happen in a vacuum. It's deeply intertwined with legal frameworks, and the interpretation of those frameworks, like we saw here, can profoundly shape how innovation unfolds. It's a constant dynamic tension.
So, a final thought for you to ponder. What stands out to you about this tension? Does the Ariad standard strike the right balance between rewarding groundbreaking research and demanding concrete disclosure? Or does it, as the dissenters feared, potentially stifle those crucial early sparks of genius before they fully materialize? Something to think about next time you hear about a major scientific breakthrough and how it might be protected. Thank you so much for joining us on this deep dive. We hope this exploration has given you a clearer, more nuanced view of a really critical piece of patent law. Until next time, keep digging, keep learning, and keep asking those important questions.